Hello, hello, hello. This is Attorney Mike Grevlin coming to you from Chicago. As usual, we got a fun one today. It's a little bit longer because I put two hearings together. Somebody sent this to me and I can't find who, and I apologize for that, but thank you because I really like it. And then I found the second clip, which is what makes this a little bit longer, but it's the follow-up that you would all ask for. So I thought, there's no other way to do it. Just put them together and run through. So we're going to have ourselves a fun late night hangout. I don't know how this time slot will work, but this is all I had for the day, and this is a fun clip. So let's get it started and see where we go here.
Yes, ma'am.
All right, Mr. Leyva and Ms. Leyva Pike, if you would mute yourselves and raise your right hands, please. Ms. Leyva Pike, would you unmute yourself and raise your right hand, please?
Strong start here.
Are you frozen?
Oh, can you hear me?
I can hear you, but you look to be frozen. Are you frozen?
Your Honor, can you hear me?
I can hear you.
I don't know why I'm tempted to check mine.
And so it begins.
Your Honor, I apologize for the technical difficulties.
Okay, that's
I think I've
fine.
got it fixed.
All right, good. All right, would y'all raise your right hands, please, and be sworn? Do you each solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Yes, ma'am.
All right, thank you. All right, Ms. Borum, this is your motion.
Your Honor, before we proceed, I need some procedural clarification as to the motion for this hearing.
Oh, Lord. No, you don't. No, you don't. But okay.
What clarification do you need?
In due sequence of motion filing, there is a federal rule in civil procedure as well as in the state of Texas that motions are to be heard in due order of pleadings. There were 5 previous motions filed as well as dates requested before their initial motion to even request a seal. And that was not provided until February. My motions were filed January 22nd at 12:23, 12:38, 12:33, 12:39, and 12:41. I have been in contact with Ms. Lopez discussing the dates of these motions and have agreed to all dates provided by Ms. Lopez. However, she sent me an email saying opposing party refused to collaborate as far as setting a date and time.
Your Honor, if I may.
You may.
I actually have the email from Ms. Lopez here in front of me. And while Ms. Pike is correct, I believe she filed several documents. They were not all motions.
No, ma'am, I just wish to have the motions to be heard.
There were several documents that were filed, and we filed ours as well, which we were able to get set today. On March 25th.
Objection, Your Honor. I was never spoken with by opposing party as to an agreement on a date. I was simply giving an email informing me that this hearing would be heard out of sequence, and absolutely no dates or times were provided to me as they were provided to the opposing counsel.
All right, let her finish her statement, please.
Thank you, ma'am. On March 25th, Ms. Lopez provided dates to Ms. Pike on the dates that her motions could be set. She said that there's not enough time on the docket today to hear multiple motions, and she has the following dates available. April 16th.
Objection, Your Honor. Those dates should have included my motions, which I am happy to do today, or to request a continuance so all of them can be heard in the same day, as is required in the due order of pleadings.
Okay, that's a big question for me. I can't tell if she's a sovereign citizen or not. She does some things that make me think she is, but in some ways she's more reasonable. I mean, she's out of her mind. But in some ways she's more rational and on track than a sovereign citizen. In some ways she's not. So I don't know. Tell me in the chat.
Okay. Let her finish her statement, please.
Yes, ma'am.
And Ms. Lopez provided April 16th at 1:30 and also April 30th at 9:30 a.m. I do not believe that there is any harm to Ms. Pike for my motion to seal to go forward today.
Your Honor, I disagree completely. This does incredible harm to myself as well as to my children. The motions were to strike perjurious filings, and they should be heard first in accordance with federal rules and civil procedure.
Okay. Let her finish her statement, please. Ms. Borum, I think you're frozen now.
Your Honor, can you hear me again? I apologize for that.
Yes, I can.
As I was saying, I don't believe that any harm comes to Ms. Pike or her case by having my motion to seal heard today, as it has no adverse effect on her pleadings or her ability to have her motion set and heard. In fact, I would say that the harm could come to me and my client and the court staff and the other attorneys involved in this case. Because if the motion to seal is not heard by the court today, then that gives Ms. Pike an additional 2 to 4 weeks to file more documents containing baseless allegations, personal information, and many things that could bring harm to yourself and other judges that have been attached to this case and the attorneys that are involved in it. So I would agree with her that her motions are not set today, but I would ask the court to go forward on the motion that is properly set, which is mine, which is the motion to seal.
In addition, Rule 21 filing and serving of pleading motions, it says that they must state the grounds thereof, stating that it is not harmful to myself or my children. 76A clearly gives strict guidelines as to how to seal a court records. And none of those. Number one, you did not provide a sufficient reason, and this motion should never even been scheduled due to that. Secondly, it is out of order. Thirdly, your opinion does not supersede the law. I apologize, Ms. Forum. However, I do think that this is incredibly painful to myself as well as my children, because there are instances of perjury as well as instances of documents that were filed that were not legal, which I am attempting to address, and I have not put anything to harm Ms. Wells in any way in any of these documents. Rather, they reflect the actions Nicholas Leyva has taken to harm myself and my children. In addition, this is important to stay open because there are multiple journalists as well as multiple child rights activist organizations who are incredibly interested in this case and have already reviewed most of the files. This is a public concern and it should not be sealed.
All right, what we'll do is, I want Ms. Leyva's motion for April 16th at 1:30 if everybody is available.
Absolutely, but it doesn't.
Yes, ma'am. Are we going to hear all motions to strike or just one at a time? And then are we going to follow with the motion to seal?
We're going to hear all of your motions to strike in order on April 16th at 1:30. I'm going to hear the motion to seal today. That was set for today.
Your Honor, again, according to, I need a procedural clarification. Are the courts in a habit of disregarding these federal rules and civil procedures out of order?
I'm not going to address that. We're going to hear it in the order that I set for today. And this motion to seal is set for today. Everybody got proper notice. We're going to hear that today. We're going to hear your motions on April 16th.
Your Honor, what about Rule 21? As far as they must state the grounds thereof, there were no legal grounds to seal my records, nor was 76A applied, which is required in the sealing of all records. There is a list of requirements that must be fulfilled by the attorneys upon sealing records. In addition, it is meant to be an open case where anyone from the public, opposing parties are able to come in and speak on behalf
She's on a roll.
whether or
Don't
not
tell
they
her.
should be sealed. So if we should be moving forward to seal them, they should at least be done under the proper grounds with time for people to present their opinions in a court of law in accordance to 76A.
All right, give me a moment. Okay.
Thank you.
Oh, we're just warming up, people. Buckle up. We're going for a ride. New Zealand in the house. Love it.
All right, I think that gives me guidance on what I have to do and what she has to present. But she may proceed with, Ms. Moore may proceed with her motion at this time.
Your Honor, with all due respect, what about Rule 21 and the validity of the motion? She presented no reason, lawful reason to seal, nor did she provide any exhibits before this hearing as to why these records should be sealed.
All right,
She provides a damn good reason coming up here.
response, Ms. Moore.
Yes, Your Honor. The motion that was filed was properly filed. I did present in the motion that the sealing of
Objection, Your Honor, it was not properly filed in regards to Rule 21.
All right, excuse me. Ms. Leva Pike, you must give her an opportunity to respond. You
Thank
cannot
you,
cut her
Elise.
off every time.
Yes, ma'am.
All right, go ahead, Ms. Forum.
I specifically asked in my motion that the records be sealed because, as she stated many times, this is governed by Rule 76A, which says that if there's a specific, serious, and substantial interest which outweighs the presumption of openness, then the court has the authority to seal the records. Also, I did state in my motion that the sealing of this records would not have an adverse effect on public health or safety or Ms. Pike's case. I think that
I like that better, Lauren.
arguments that need to be presented today go to the weight of my motion and whether or not the court should grant it.
Your Honor, she did not provide any arguments in the motion, and she just
She's not required.
twisted the language of 76A. It says it can only be sealed if it is to harm the public. Whether or not it could harm the public is not part of the conversation here. It specifically states it has to be a public issue.
Thank you,
And the public has a right to speak on it before they are sealed.
All right, Ms. Forum.
A couple things. First of all, I believe that today's motion will be based largely on legal argument. Please excuse me. As evidence in my position is really not necessary because all that I need the court to do is to take judicial notice of the file and then be given an opportunity to point out the things that have been filed with this court that are currently a part of the public record, which I think absolutely pose a specific and serious harm to the people that are named within these documents. Secondly, one thing I did want to point out real quick, I wanted to ask the court how long we have set on April 16th. I do have a setting in a different county at 1:30 on that day, but I could certainly push it back as it's only a deposition. I would just like to know how long you think we'll need on the 16th.
We'll probably need all afternoon. Let me look and see.
Yes, they're following it to the letter. Yes, she's better than your average pro se soft sit type. She is. Still horrible, but better than average.
She's only given you an hour. I've got another case that I have to do a motion to sign temporary orders. That shouldn't take too long, so we would have to take a break and come back.
Oh, I'm glad to have you. Oregon in the house. Thank you.
Let me see what's available on the 30th. On the 30th, we have it pretty clear all day. Are you clear all day on the 30th?
Yes, ma'am, I am clear on the 30th. I actually had a deposition set in San Antonio that day that just got moved.
Is everybody else clear on the 30th?
Yes, ma'am.
Yes, Sean.
All right, we'll move it to the 30th then at, let me see what time she is here. At 9:30, and we'll give it all day.
Thank you, Your Honor.
Okay. All right.
Mm-hmm.
All right, Ms. Borum, you may proceed with your motion.
We'll give it all day from the judge, by the way, is a complete recognition that she's alone and nothing will go down smoothly.
All right. Thank you, Your Honor. I've brought this motion to seal the records before the court today, specifically because Ms. Pike has filed several documents, some of which I believe are improperly filed within this case. But many of these documents include allegations that the court, myself, Ms. Newell, Judge Bennett, and Ms. Lopez, and other people connected with this case are participating in child trafficking, that we have committed fraud, that we have taken part in actively trying to harm these children that are the subject of this suit. Ms. Pike, as I'm sure the court knows, for quite some time had absconded with the children, which led my client to getting custody of these kiddos. My biggest concern is that—
Your Honor, I just want to state for the record that that is not true. The final order stated that Nicholas Leyva and I had an issue with our communication, and in order to promote better communication, he wanted to try something new, and there was no fault found with me.
I think you should try something new, namely shutting up when someone else is talking. I mean, that right there is all you need to know. She just loses so much credibility with that right there.
In a court of law, nor was it found that I absconded with the children, nor broke my mediated settlement in any way, shape, or form.
Yep. Hi, Beverly.
All right, appropriate at this time, Ms. Leyva. Please wait till it's your turn to talk. All right, go ahead, Ms. Borum.
Mm-hmm.
She's frozen.
Ah. Yeah, but can she dance, Gregsy? That's the question.
What are you waiting on?
There's a quick question for you, Your Honor.
What is it?
I have filed a notice of judgment. We sent certified mail notice to the last known address. It came back undeliverable. We don't know where this lady is. What would be our next step?
Publication.
We can do publication with
Yes.
that? Thank you, Judge.
All right, thank you.
Your Honor, I believe that Ms. Borum might be having some internet issues, so we could just wait for her to be able to log back on.
All right, I am. All right, you're back, Ms. Borum. You'll unmute yourself, please.
Yes, ma'am, I apologize.
They just, by sealed here, they just mean that the public can't view the court file. And the reason why is the reckless allegations that she's making.
Apologize for that.
And thank you, Secret Ms.
I switched over to the hotspot on my phone instead of my Wi-Fi network, and I believe it's working better. Can you guys hear me?
Yes, we can.
All right, thank you. as I was saying before my computer froze, which I apologize for, there have been allegations of, as I said, court staff, including the judges and attorneys involved in this case, that were involved with fraud and child trafficking and actively engaging and harming these children. In addition, our home addresses are included. And so these allegations, which are baseless and inaccurate and not filed properly, are of public record, and they are joined with our personal home addresses and our residence addresses, email addresses, and things of that nature. I believe that this is set up, well, as Ms. Pike has just said, that she wants to make sure that the public and reporters and things of that nature see these claims and know where to find us at our homes with our children.
Your Honor, I never stated that.
The intent, in my opinion, and certainly if it was not the direct intent, certainly the very grave risk here is that someone will see these allegations and believe that myself or Ms. Newell or yourself or Judge Bennett have actively been hurting children and will take their own steps to make sure that we are, quote unquote, stopped from doing it in the future. I believe it poses a risk not just to us, but to our families. And I believe that that was absolutely the intent of Ms. Pike. But even if it wasn't, it certainly is a substantial risk. And I believe that that absolutely outweighs the presumption of openness in this case. Also, I believe that there was, I'm not sure how long it is, I'll be honest, it was just filed the other day, an affidavit that appears to be around 50 pages long. I haven't had a chance to digest it all. I feel confident that it also has information in it that is misleading to the public. I know specifically it alleges that Judge Bennett made a private call to Virginia and asked for a favor. That favor being, quote unquote, the brutal police kidnapping of the children, to have them sit with strangers until picked up by Mary Beth Adcock. And
that rhetoric straight from the Chile playbook. You know, just take any common occurrence, like the police took your children because you lost custody because you lost in court. So, you know, it's a brutal kidnapping. Okay.
Trafficked to the state of Texas. Now, that's just one little piece that I found just a moment ago. But that clearly insinuates that Judge Bennett is involved in child trafficking and in the brutal treatment of children. Judge Bennett's address appears throughout this file, her home address, specifically on the criminal complaints that were filed by Ms. Pike. I don't know if these were ever filed in a criminal court. I know that they were filed in this family case, which again, I believe is inappropriate. They are not certified and not admissible into evidence, even within a proceeding, much less in the court's file. Again, these criminal complaints list names and addresses and personal information. When you couple these allegations with the information to find the people who are alleged to have perpetrated these allegations, it presents a very serious threat to those people. I will absolutely state to this court, although it's not the purpose of this hearing today, that I have not been involved in child trafficking. I do not abuse children. I have not behaved brutally or encouraged any brutal behavior towards anyone. But I do have a 9-year-old son. And I would prefer that the public in general, especially misinformed by these baseless allegations, not know where to find me or the judges that I sit in front of or the colleagues that I practice with. And I believe that that is absolutely a serious and substantial interest that outweighs Ms. Pike's interest in making sure that the whole world believes that everyone involved in this hearing, except for herself, has injured children intentionally.
Oh, thank you.
Thank you.
All right. Ms. Leyva.
Yes, ma'am. First of all, I want to state that no fault was found with me in the final order, and I had never absconded with my children, and I kept our mediated agreement to the letter. Again, you can look through the records. No fault was found with me by Judge Catterton in any way, shape, or form, and everything that was said was found to be baseless and lies and perjury by Nicholas R. Leyva. And as far as accusing,
Okay, if that's true, then why don't you have custody of your children, and why are we here?
I've never accused you, Ms. Wells, in any of the documents. You can review them. They are not baseless. They actually are backed by federal law, Texas codes, Texas statutes, as well as backed with evidence through the
This is a custody case in Texas. Federal law's got very little to do with it. You know, all these references to federal law are silly as usual.
documentation of the courts. Additionally, I have come to the belief through reading through my records that Miss Bennett was actually harmed in this case by Miss Lindsay Newell as well as Nicholas Leyva, considering the level of perjury. The affidavit filed was not even notarized.
But
So these claims are not in any way baseless, and they are important to recognize. Additionally, I do not want any harm to come to anyone ever. I do apologize if anyone would insinuate that or think that I have anything more than wanting justice. I simply want justice. I do not want anyone to be harmed. And I do believe 76A does still need to be applied because there are many things in my records that are of public importance. And I would suggest, due to Ms. Borum's, due to what Ms. Borum just said, and in regards to protection for herself and her son, as well as everyone else's families, that instead we redact all addresses from all the pleadings. And that should take care of Ms. Borum's concerns.
Okay, so I think this woman has jumped the shark here and you know, made herself out to be a lunatic. But this is an intelligent play. This is better than your average sovereign citizen sort of thing, where she says, "Yeah, I've got no problem with it with redacting." So I give her 2 points there. I mean, overall, I think her approach is awful, but that is wise because it makes you look reasonable to the judge.
Your Honor, if I may.
All right, Ms. Borum.
Given the nature of the concerns, I don't believe that redacting the documents is going to be an adequate remedy in this case. The reason being because while it is very troubling that my personal information has been put in public record in conjunction, it's also reached the level that the allegations are so egregious that just having my name attached to them could lead someone to come and try to find me. And certainly Judge Bennett. Judge Bennett, I believe, is probably the only person that's mentioned more than Judge Bennett is Ms. Newell. And I have had items delivered to my house, my home. I know that, excuse me, Your Honor, I apologize. And I know that other people connected with this case have as well. And I believe that the allegations will continue. If Ms. Pike believes that these things have happened, then that should be properly tried in your court. But to simply put them out there and to attach our names to them, it goes way beyond defamation, Your Honor. It's a threat. And if she indeed does not want anyone to be harmed and doesn't want to place anyone in danger or their families in danger, then I would argue that I agree with her. I also agree that 76A should be applied. Absolutely. And I think that under 76A, that the court has the authority and that in this particular case, the only remedy available to apply the protection that I think even Ms. Pike agrees that we need at this point is to seal the records. And again, I don't believe that that poses any damage to her case whatsoever. It simply means that the public in general can't come, potentially at her request, and read through these files and simply believe the things that are in there with our names on them.
Your Honor, everything I have filed is backed by Texas statutes, federal regulations, and a provision of evidence. I'm sure that you've not had a moment yet to read my request, which the affidavit is attached to. It is incredibly long. However, that is because there has been just this extremely high level of deception throughout my case by Ms. Newell and Ms. Leyva. I believe they perpetrated perjury on Ms. Bennett. I'm not entirely certain.
Objection, Your Honor, to anything that goes before
Your Honor,
higher order. She's getting into things that were...
But I cannot object.
Feedback. I'm sorry. Please stop. We're getting feedback and I don't know. Does somebody have a cell phone on near
This
the...
is not me, by the way.
I believe I did, Your Honor. And the objection, which I concur with, was that Ms. Pike is now going back beyond the previous order and she's testifying as to things that happened prior to the last final order that
Your
was put.
Honor, if there is perjury before the order, that is still a perjury and it affects the final order. Just because a new final order,
What are you thinking?
final order is void if perjury is found within the case in accordance with federal guidelines.
All right.
And therefore, the perjury still applies. And Ms. Borum is not denying perjury within the case. She's just simply stating that it should not have any effect as to what is occurring now.
Your Honor, I do have one more quick issue for the court, if I may, please. I also, within my motion, I amended my motion about a week ago, and I asked the court to please waive my client's requirement to disclose his employment information to Ms. Pike, as he's required to do under the prior order. The reasoning for this is because—
I agree.
And
fine, I don't care where he works.
All right, she agrees to that.
perfect. Thank you, ma'am.
All right.
Again, another good move. There's no really good reason for her to get that information. She's entitled to it as a matter of law, but to assuage the court, you just say, yeah, I don't need that, and that helps keep her in the game. I mean, she does some crazy stuff, but then she knows when to retreat on something that's just a loser, and that shows a level of intelligence.
Ms. Knoll, do you have a dog in this hunt?
Your Honor, I agree with everything that Ms. Borum has previously stated, and in my opinion, there's no less restrictive means other than sealing this case under 76A, and I do ask that you seal the records in this case, Your Honor.
Ms. Borum, do you have any documents that you can direct me to that I can review specifically that supports
Probably.
your motion?
Yes, Your Honor. On January 21st of this year, the criminal complaints that were filed with the court. On March 5th of this year, it's entitled Violation Warnings that were filed with the court, and the affidavit that was filed on March 30th of this year.
Your Honor, that affidavit is connected to a request to vacate final order due to intrinsic and extrinsic fraud. And it is just a request as of now. It is not a motion. However, that affidavit is also connected to federal cases as well as for
when you request a judge to order something, that's a motion. That's what we call that in court.
Virginia tort cases.
Okay, hang on a second. Ms. Pike, I'm going to let you know that when y'all are talking over one another, we're not getting a clear record. So.
Sir, who are you? May I just have it for the record?
Mr. Moss is the court reporter. He's taking everything down.
Yes, sir. Thank you. I apologize.
Okay.
It is a court, as Ms. Pike just stated, it is in fact part of the court's record, which I'm asking to be sealed today. And one other request that I would just have, Your Honor, is that I've been trying for probably upwards of 6 months now to get Ms. Pike served. Of course, she's made a voluntary appearance in this case, but I also have an enforcement action that I need to serve on her. And I would ask on the record if she could either provide me with her address where I could get that served to her properly, or if the court could order her to provide that to me.
All right, Ms. Leyva.
Your Honor, I do not feel safe providing my address. Again, I understand you have not read the request. However, I have sufficient reason to not provide my address. If she would like to serve me, she is more than welcome to e-serve me through the Texas Filing Service. I can also provide a P.O. box.
That's
Oh, yes. The incredible irony of her not being comfortable providing her address. The attorney handles it here, but the facial expressions and the response are spot on.
That's not on an enforcement. Unfortunately, she has to serve you personally with it. Do you have a request where you feel comfortable that she can arrange a time to have you served at?
Yes, ma'am. I will have to get back to her with that. However, I have consistently attempted to reach out to the party as far as documents, and I just received my documents that were never served to me initially that have also been used in a court of your court of law, or have attempted to be just recently, and I need to finish reviewing those documents as well.
And Your Honor, I would like to point out at this time that Ms. Leyva just testified under oath that she does not feel safe providing her home address to this court or to the people involved in this case, but she certainly feels safe providing ours.
Again, Ms. Borum, I agreed with you, and I request that the courts redact those addresses. However, that is not sufficient reason to seal the case records themselves. And I would happily agree to redacting any and all addresses and personal information from my case files.
And just keep the wild accusations with no foundation in fact right there for all the world to see.
All right, the problem is that we can't require the clerk to go through each record and re-image it by redacting. So that is, I don't think, a viable option. I'm going to review the documents cited by Ms. Borum, and once I review that, then I'll make my ruling. Is there anything else anybody else wants to say?
No, ma'am.
No, ma'am. Thank you.
Okay.
Are we excused?
Yes, you are excused. I'll get you a ruling by email, all right?
All right, thank
Your
you.
Honor, I request that the ruling be done through video conference. As I stated, there are multiple journalists as well as child advocacy groups who are interested in the outcome of this hearing. And I think that it is not sufficient, especially considering it is to seal records and in regards to 76A, to be privately forwarded to us. It should, if anything, we should reconvene at a later date.
That says it all.
To complete the hearing after you've had a chance to review the documents.
It's been in the court file, but I will do it by email, and that's the way it's going to be.
And don't forget to hit like and subscribe.
Okay, so I just put Oscar in there to break it up. I saw Oscar the other day. He's so darn cute. Anyway, so this is a follow-up hearing, and what we have is, it's not directly on point, but it follows the saga, and it does this. I think this is more recently. By the way, both of these are from a small channel that I believe is sympathetic to her. Because he titles it, he says something about they take her kids under suspicious circumstances or something like that. So for whatever that's worth, I put links to the videos in the description below. But this next hearing is, she's going in front of a judge because she pulled the Blandino / Chili / everybody maneuver of trying to get this judge off the case. And of course, then it needs to be heard by another judge, and that's where we go now.
Don't make Oscar beg. It's rude.
Ms. Leyva, this is, okay, there you are. All right, Ms. Borum, this is Judge Wallace. Can you hear me?
Thank you, Mortimer.
Can't hear you.
Is it working now?
Yes.
All right.
And Miss, the name on the screen is Sarah, but that's you, Miss Sarah Leyva?
Yes, sir. Sarah Leyva Pike.
All right. All right, I will call this case hearing at this time. This is cause number 325-575-862-15. In the interest of Joshua R. Leyva and Samuel D. Leyva, minor children, and we are here for a hearing on the amended plaintiff's request for immediate voluntary recusal of Honorable Judith Wells and hearing
Thanks, Mike.
March 31, 2021 to be declared a mistrial. I am Senior District Judge R.H. Wallace, sitting by assignment to hear this matter in the 48th District Court today. These proceedings are being conducted remotely by Zoom, and also are being streamed on YouTube. The court reporter is taking a record of the proceedings, and that will be the official record of these proceedings. Parties are ordered not to record these proceedings, otherwise the same as if you were in court.
I like this judge, but he is straight from Central Casting for serious old Texas judge.
All right, Ms. Leyva, I have reviewed your amended motion request for recusal and also the response that was filed by counsel for Nicholas Leyva today, and I'm happy to hear any evidence, testimony, or otherwise that you would like to offer in support of your amended motion to recuse.
Yes, Your Honor. Is it okay if I get started?
Yes.
All right. First of all, I want to state that there was an inaccuracy on Ms. Borum's response. She stated that I was accusing her and Newell of rape and molestation of a child. Sir, that is inaccurate. They are actually named defendants in relation to that. However, they themselves are, as in committing perjury, suppression of evidence, however, not specifically doing harm to the child physically themselves.
That just shows a complete lack of experience in this area. If you file a bunch of pleadings, they speak for themselves. You don't have to interrupt at the beginning and say, I'm going to verbally tell you what I freaking wrote out for you. You assume that the judge, to the extent he cares, saw it.
I also noticed that she never actually stated that anything I said was false. In every single one of her points, she stated that I had unspecific facts. So, Your Honor, I wish to present the very specific facts of what has been occurring actually for the last 2 to 3 years. On May of 2015, Nicholas Leyva and I signed a irrevocable mediated settlement with the assistance of a court mediator. On January 29th, 2016, we then had it signed by a judge and affirmed. In August of 2018, Lindsay Newell filed 2 violations for enforcement where she committed third-degree perjury. In these violations, neither one was a violation of our irrevocable mediated settlement, and she went so far as to reword in her filings part of the mediated settlement, intentionally committing fraud upon the courts. Additionally, the affidavit that Nicholas Leyva filed with the petition to amend child custody, again with violations that were third-degree perjury and were not true, his affidavit was not signed. However, it was stamped. When I did a little research, the notary is his friend on social media, and I'm not sure if she could.
Oh, here we go. The focus on the notary. The notary is just not that relevant. And her big gotcha, her big aha, Perry Mason gotcha moment is that this guy apparently is connected on social media. I mean, if that's the standard, I don't know. I guess I have a conflict with every one of you.
Colluded with him, or if he simply just stole her stamp when he was at her house and stamped it for himself. I do not have evidence of that. However, it is very clear that page is not signed by a notary.
I don't know if you, Mrs. Borum, or not. Please don't interrupt these hearings. Only one person can talk. Now,
so this led to a jurisdiction hearing, which was made again.
Ms. Borum, I've muted you. Let me interrupt you a second. All right, go ahead and unmute.
Okay, can you hear me, Your Honor?
Yeah, not Ms. Borum, Ms. Leyva. The purpose.
Thank you, Your Honor.
The purpose of the hearing is to determine whether or not there are grounds for recusal of Judge Wells for any of the reasons set forth in Rule 18B of the Texas Rules of Civil Procedure. We are not here to hear arguments about what previous merits of the case or anything. It's your opportunity to present grounds to the court for recusing Judge Wells, and that's what I would like to.
So, Your Honor, you have interest in also helping in hiding the original fraud that was committed against myself and my children. There are many laws stating that anything that happens with fraud has no statute of limitations, number one, and any judgment procured with fraud is void. And Ms. Borum is attempting to seal records to hide extrinsic and intrinsic fraud
That's great. She's reading some bright line rules from law books. 2 points. However, they're not applicable, and you haven't shown fraud. You've been in court a bunch, and you have not established this. So you just assume, a bunch of things, and then make your argument based on that. It doesn't work.
On a void order. And so it all pertains to Ms. Wells, because Ms. Wells, in that hearing, and which I will get to in just a moment, of how she specifically acted outside her judicial capacity and why she should be recused immediately. However, a recusal is not necessary because the order is void, and simply someone just needs to uphold the law in regards to our irrevocable mediated settlements. Because everything that has occurred since our irrevocable mediated settlement is fraud. Not only is it fraud, due to the physical force in which my children were removed by police under a fraudulent order, which stated that I removed them, that I kidnapped them from the state of Texas despite an irrevocable mediated settlement. It also falls under US 15 for sex trafficking of children, or through
I'm guessing. I have no idea. I don't know the underlying facts here. And by the way, I can believe that the state can get out of hand. I have a video on my channel where CPS and the judge hammers them for it. In Texas is completely out of hand. I'm sympathetic to that idea, but based upon her demeanor and the way she acts and the fact that she continuously loses, I'm not believing her.
Force, fraud, and collusion, which I was going to get to, Your Honor. And I do apologize. I'm sure you have not had the time to review the records yourself and are unaware that these things have been occurring. However, I'm almost to the point of Judith Wells and why she should be recused. I'm just giving you the background and the full story of what has occurred and why Ms. Borum responded to all allegations with unspecific facts.
Well,
And did not provide any direct, argument as to what I was saying is untrue.
what I would like for you to address are the grounds set forth in Rule 18B of the Texas Rules for Civil Procedure.
Your Honor, that is not just the only thing, but in regards to civil procedure, she completely ignored.
Yeah. Interrupt the judge when he's when he's telling you the way it is. Good luck with that.
Her due process of filings. She has received 3 requests to vacate due to intrinsic and extrinsic fraud. During the hearing to seal records, when I brought these allegations to Judith Wells' attention, Ms. Catherine Borum responded, the fraud occurred before the final order. She herself admitted that fraud was occurring. In addition, I have not seen my children since they were kidnapped, nor heard their voice in over a year. This is intentional contract interference of an irrevocable mediated settlement, intentional parental rights violations, perjury under TPC 3702 and 03 of aggravated felony level 3rd degree, extreme parental alienation, and intentional conflict, intentional infliction of emotional distress, and RICO collaboration between Nicholas Leyva, Lindsay Knoll, Catherine Borum, and
Leyva. Look, Miss Leyva, please slow down. I'm trying to make a record.
Apologize, Your Honor. As you can understand, I apologize. This is very emotional for me. As I said, I've not even heard my children's voices in over a year due to the intentional parental alienation and continual abuse of Nicholas Leyva. Awful.
That is, and she is rude. And I think probably wrong as a matter of law, although I would not give a final thought on that. But what she's got before him is a motion to get the judge kicked off her case. And, so she does some sympathetic things. I feel bad that she hasn't seen her children, but I just highly suspect it's the product of her actions. And they're on display here.
In addition, Judith Wells not only ignored Borum's admittance of perjury in the procurement of the final order.
Wait till the end. I agree. She's got an odd affect here, and then she has this weird thing when she's at the end. She's laughing when she should be crying. I think she's trying to cry and can't. It's odd, and it is reminiscent of Amber.
She then cut the hearing to silence me, and then sent an order stating that even if my records weren't officially sealed, she would be receiving a list from Ms. Borum about which records did need to be sealed, if not all, when the only issue is addresses, which can easily be redacted and are the job of the court, the district clerk, which I happily agree to. Any addresses, I do not want any harm to come to any parties involved. I would happily remove their addresses. However, Ms. Borum was particularly interested in my affidavit to vacate due to intrinsic and extrinsic fraud, and has yet to actually state how anything is a falsehood. There was also a violation of due process, as I said, according to filings. That's Johnson versus Zerbis. There's a whole list. I'm sure you don't want me to go through them. Also,
yes,
where there's no justifiable issue is presented to the court through proper pleadings. Ms. Borum did not provide any proper pleadings in regards to sealing the records. She simply stated she wanted to do it in the best interest of her client. There was
she provided pleadings and argued it in the last video. I got the basis completely from watching that video.
Absolutely no danger to the public in any way, shape, or form, and the only people to gain from sealing my records are Miss Lindsay Newell, who committed third-degree perjury, and Nicholas Leyva, as well as Judge Patricia Bennett. Your Honor, you know exactly what's happening. And Ms. Borum knows exactly what's happening. In the hearing with David Evans, he even asked her to be a witness to state that what I was saying was untrue, and she refused.
It's a mystery.
Ms. Borum.
Yes, to testify. I'm sorry.
Thanks, Jennifer.
Were you saying David Evans asked to testify?
He asked Ms. Borum at the last hearing to testify and asked her if what I was saying was untrue, and she said, I do not wish to be a witness. So she herself knows that these crimes have occurred against myself, my children, the public. This is treason. This is absolute treason. The laws covering judges.
Capital felony treason. We finally got there. She's not also reading the room. When the judge is doing this, letting you cut him off and stuff, it's not because he's weak. It's a complete lack of respect for your position. If I was doing this to a judge and getting into it with them, they would get hot and nasty fast because I actually know what I'm doing and I pose a threat. This is someone who's just thinking, okay, whatever.
And other public officials are found at 5 USC 3331, 28 USC 543. I'm sure you know where they are. And if a judge has not complied with all those provisions, he's not a judge, but a trespasser upon the court.
It appears you're reading from something.
I am, Your Honor. I have notes because I cannot remember all the laws in my brain, unfortunately. I wish I could.
But please slow down so that the court reporter can take down what you're saying.
I apologize, Your Honor.
T-shirt right there.
Also, as I stated before, the fact that they even have the children to begin with, the final trial, Miss Lindsay Newell flat out lied to the judge and stated I failed my drug test while holding them in her hand. No fault was ever found with me, which breaches my 1st, 4th, 5th, 6th, 7th, 9th, organic, 13th, and 14th Amendment rights under Bill of Rights Articles 1, 2, as well as the 11th Amendment. This crime has been occurring against me and my children for over 3 years, Your Honor. And every judge so far has not only ignored all the evidence, but has
it occurred to you that they've listened to the evidence and ruled against you because you're wrong as a matter of law? Has that possibility occurred to you, ma'am?
Assisted in protecting Miss Newell. I'm sure my husband is not that important. I'm sure it's about Miss Newell, not about him. And I am not asking for anything to happen to them other than the return of my children and the irrevocable mediated settlement, which is our lawful contract to be upheld by Tarrant County courts. But if that is not a possibility, then as I said, Judith Wells did not follow due process of filings. She was blatantly biased in every way possible and did not present herself as someone operating for the courts, but rather someone who is operating in collusion with Ms. Borum and with Ms. Newell.
I don't know. We just saw a video of that judge. She seemed eminently reasonable to me, but you know.
Is that all you have?
Yes, sir.
All right, Ms. Moore, respond.
Yes, thank you, Your Honor. Can you see me okay?
Yes.
Okay, there was a little feedback on my end. Okay, I think that's better.
It's my fault.
Am I coming through?
Yes.
All right, thank you, sir. I would like to briefly respond. I know that
Let me give you the same admonition that I did to Ms. Neva. I'm not interested in hearing about rulings that people disagree with or agree with. My only concern here in this hearing today is whether there is any evidence that's being offered to show that there would be grounds for recusal of Judge Wells under Rule 18B of the Texas Rules of Civil Procedure. So please don't rehash any arguments of that do not go to those issues. Okay, go ahead.
Yes, sir. I would like to make a brief argument to the court. As you know, I did file a response earlier to Ms. Leva's filings. First and foremost, as I'm sure the court is certainly aware, that under Rule 18A that addresses the recusal of judges, there are several different grounds that are set forth that must be adhered to in order for a judge to be recused off of a case. First and foremost, the motion must be verified. And I would point out to the court that Ms. Leva's motion is not verified. Secondly, she must state with detail the facts that are either within her personal knowledge, or if they are for information and belief, they would be facts that would be admissible in court and specifically stated. From reviewing her motion and without getting into the merits of the case or the previous affidavits or hearings, I would say that it appears that she's arguing under subsection B1 and subsection B2, stating that she believes that Judge Wells' impartiality could potentially be questioned and or that she has a personal bias. These are the issues that she appears to be attempting to address within her motion. I would object to her motion on several grounds. First and foremost, because there aren't any specific facts that are alleged in any of her points which do attempt to go towards being biased or impartial. Secondly, I would point out that Judge Wells is, I believe now, the fourth judge that's been involved with this case. I believe that, and I have only recently come on to represent Mr. Leva, but to my knowledge, the only hearing that's taken place in front of Judge Wells was the motion to seal records. And Judge Wells did follow the Texas Rules of Civil Procedure, and she ruled on that motion. There were several other motions that had been filed with the court, but not properly set. At that time, Judge Wells did, in fact, personally set those motions. They were, of course, stayed because Ms. Leva began to file multiple motions for recusal. Within her motion, as it pertains to bias or impartiality, first and foremost, she says that she believes that Judge Wells has a personal interest in bias due to her relationship with Lindsay Newell, who is my co-counsel, and she says Christiana Borum, but I assume she's referring to me. She says that Judge Wells did not deny inappropriate relationships with amicus or ad litem attorneys. Your Honor, there is nothing here that specifies why Ms. Leva believes that there's an improper personal relationship between any of the attorneys in this case and Judge Wells. Further, I will represent to the court as an officer of the court that I do not spend time with Judge Wells personally, aside from perhaps being at one or two bar functions where I have seen her. I certainly don't go on vacation with her and have never been invited to do so. So I would object to this particular allegation and the fact that I don't believe that Ms. Leva has provided the factual basis that's required under Rule 18A of Civil Procedure. Secondly, she seems to have a problem with Lori Robinson. To my knowledge, Lori Robinson has not served as an amicus or an ad litem attorney on this case, and I don't know how she's relevant to these proceedings in any way whatsoever, quite frankly. She goes on to say that the improper personal relationship has to do with the allegations of rape, molestation, child abuse, etc. Again, she here says Christina Bourne, but I believe that she is referring to me. I'm not aware of a federal investigation, and regardless, any allegations of behavior on my part or Ms. Newell's part, I don't believe are relevant to the recusal of Judge Wells in this case. As far as the allegation that Judge Wells unlawfully violated her constitutional rights by asking her to provide an address, I would represent to the court that that was done because I had been completely unable to serve Ms. Leyva with process on an enforcement, and Judge Wells instructed her to give me a location where I could serve her, whether it was her address or not. She, of course, has refused to do so.
This woman spent enough time playing around with the law that she knows that that's nonsense too. An email, yes, you can get the information to somebody, but under the code, you need to mail it to an address. So a lot of times to effectuate service, you need an address, not because you can't get it to them via email, but because the law requires it.
There's an allegation that Judge Wells has engaged in judicial misconduct by blatantly ignoring any and all requests to vacate a final order. Well, that's untrue, because at the motion to seal, which was properly set before Judge Wells, she personally set the additional motions, some of which were rather nonsensical, to be honest, but she set them regardless on a specific date. She set them so they could all be heard on the same day, and Ms. Leyva would have an opportunity to present all of her grievances to the court. Unfortunately, again, the motion to recuse was filed, which stayed those proceedings. As far as my request for sanctions and attorney's fees, I would tell the court that this is the second motion to recuse that Ms. Leyva has filed. It is essentially identical to the first one, save and except that she included a rather large paragraph at the beginning, which ran through facts and procedure and allegations that she's made in this case. To say that Judge Wells has been blatantly biased in every way possible is simply disingenuous. I would argue that Ms. Leyva is simply unhappy with the results of her case. And
boom. That's it in a nutshell. This attorney's doing a fantastic job all the way through, but there she just said it. She's found all sorts of stuff. She's just unhappy that she lost. That's it. And that explains everything.
And to say that Judge Wells has been biased or inappropriate or that she is a trespasser on the court, there's simply no foundation laid out, even made by Ms. Leyva, to support this. This is now the second hearing that I've had to defend for the recusal of Judge Wells. Secondly, I believe that a motion was filed recently by Ms. Leyva where she again requests that Judge Wells be recused without any additional facts being included. And so for that reason, I would ask that Ms. Leyva be ordered to pay attorney's fees in this case of $3,500 for the result of me having to defend these multiple motions.
Yes.
Thank you.
All right. Any other evidence to offer, Ms. Neva?
Yes, sir. I do want to
just watch us. We're nearing the end here, but just watch her affect and the way she does this. I alluded to this earlier, but it is just bizarre, like her facial expressions and the way she sort of ends this thing.
A brief statement in regards to what she just said. Number one, according to 18(1)B, there is very blatant evidence of judicial bias in accordance with that, and there are specific filing facts, especially in regards to due filings. The hearings were not set. They were set by the courts, and I was offered multiple dates. However, opposing party refused every single date and then set the hearing to seal records. And again, at the core of this is third-degree perjury and child trafficking. You cannot ignore that just because you want to focus on recusal. Actually, it is U.S. 18-4, misprision of felony. Even if I don't specifically put anything in this filing, there is more than enough in my case records, if anyone would care to review them, showing the extent of the perjury, the bias, the misinformation, as well as documents by judges such as Patricia Bennett that had blatant lies on them, like stating the boys were in Texas 6 months before the hearing. Your Honor, this is a very serious issue that I have been dealing with, and this is not because I was trying to recuse her a second time. I put in an amended motion, and I am not a lawyer. I am just a mom fighting to see her children again. And I did not know that amending the recusal would call for a second hearing. I do apologize for that. Also, I have no money. If you look into my case records, I have filed as indigent, and I have not.
Indigent. That's indigent. If you don't know the word, just say you're poor. Okay.
Had any money coming in due to the constant legal abuse, deception, perjury, and legal abuse that I have sustained for over 3 years. Your Honor, Judith Wells is not only interested in protecting Newell due to this case. Even if I cannot present the facts, you can look it up yourself. It's Brad Lamb and Carice Washington. There is a federal investigation, and it is into crimes. Even if Wells is not named as a defendant, it all occurred in her courtroom for almost 5 years. By Ms. Borum as the attorney, and by Ms. Newell as the Atticus attorney. Your Honor, I don't know what to say. We all know here they broke the law. We all know that what is happening to myself and my children is a huge violation of the Constitution.
No, we don't know that. We don't know that. You're making that allegation, and you've yet to prove it because there have been no consequences coming forth from it. So just begging the question that doesn't work for you.
Bill of Rights, basic human rights. And I just ask that you offer relief for me and my children.
Spot on, Susan.
And do what you can in your power, and definitely recuse Wells if that's all you're able to do. Thank you.
All right, based on
that's Judge Wells to you.
the amended, the evidence and arguments presented, and concludes that the motion should be denied. Therefore, the court is going to deny the plaintiff's amended request for immediate voluntary recusal of the Honorable Judith Wells. The court would also note that it appears that a almost identical motion was previously presented to Judge Evans, and that's going to be that motion was denied as well. As far as the,
I mean, what is this right here? She's putting on like she's crying. She's giving like it's actually worse than Amber Heard, and that's saying something. That's a bold statement I've just made. But she's trying to like doing a sniffle, and then she's got a big grin on her face simultaneously.
Request for sanctions. The court is not going to impose sanctions. While I appreciate the response filed on behalf of Mr. Leyva, I think it's so facially insufficient and factually insufficient that it's really not necessary to be expending attorney's fees to oppose those. You're certainly welcome to participate in the hearing.
I agree with the judge here, but you gotta really get into what that ruling was. He's like, this motion sucked so bad that I'm not granting attorney's fees to defend it because it didn't rise to the level of actually having to think about it. So it sort of helps this woman in that he's not granting attorney's fees, but insults her at the same time.
But I'm going to deny the request for sanctions, at least at this point. But that'll be the ruling of the court, and I will get an order entered to that effect. Anything else on this motion?
No, Your Honor.
We're committing a felony. Just going to say it on public television. Right now, all of you are committing felonies. You have a wonderful day trafficking children.
All right. That'll conclude the hearing, and you can leave the meeting. Thank you.
Thank you.
Well, there you have it. The judge did the right thing in terms of denying the motion. I would have hit her with some attorney's fees. I know why he didn't. He didn't because she doesn't have any money and it's pointless and it'll just create more conspiratorial nonsense, and he doesn't want to do that. But she deserved it for all the world. She did file a frivolous motion. The right thing to do is to assess some attorney's fees to her, because that attorney did have to prepare for this thing. I agree with his thing, is like his ruling in the sense that it's like this motion is so bad. However, the attorney still had to prepare for it. She still has to be there. And she doesn't know that the judge is going to see it that way. So she has to do it as if it's contested. So, you know, that's a minor point. He gets the big things right, and I agree with him on it. But I would have probably assessed some attorney's fees to her, and I would have held her in contempt for what she said at the end. I would have held her in contempt, plain and simple. After a ruling, you don't sit there and lob bombs about child sex trafficking at a judge. And I think he's a good judge, whatever, and certainly within his discretion. So I'm not saying that. I'm just saying if I was sitting on the bench, I'm ringing you up for that. I'm ringing you up for that, and you're going to spend the night in jail, at least. And this is why I'm not a judge. Thank you all for coming out. I really appreciate it. There's some wild stuff coming up here. Law and Lumber is going to be in Chicago this weekend. I think we're going to do a stream on Saturday, and there might be a meetup sometime Saturday in Chicago if anybody's around in the Chicago area. I don't know what'll happen with that. We don't have it figured out, but but we are going to do a stream, and I think we're gonna have a few drinks. That should occur on Saturday this weekend. That's just a little heads up there. And thank you all for coming out. I really appreciate it. I didn't know, but it was good participation. I didn't know about this time period, and I didn't know about this length, but I thought that was an interesting clip. And I appreciate everybody showing up and hanging out with me. It was fun.